Hi, this is Steve Dale, and I'm the trustee of the Golden State Pool Trust. Today we're going to talk about a program called Perspectives on AB133. Now, before we get started, this program has been approved for CLE credit by the State Bar of California, by the North Bay Housing Coalition provider number 14598. This program has 3 codes that are announced during the program that the viewer will need to record to verify participation in the class. If you wish to receive MCLE credit, please download the MCLE credit form at gspt.org and look for the tab that says Attorney Resources. Find the proper form and fill in the proper codes for each section. To be placed on our mailing list for future programs or to receive assistance for MCLE credit for this program, please email amy@gspt.org. So let's go through this. What is AB133? Well, to quote from the National Health Education Law Project, in 2021, the California legislature passed its new budget that expands and improves health coverage for millions of low-income Californians, and to facilitate that expansion, a key budget health trailer bill named AB133 was signed. This historic spending plan aims to expand health care for undocumented immigrants, alleviate homelessness, dramatically expands behavioral health services for youth, and helps Californians still struggling with the pandemic. The objective of AB133 is to transform California's healthcare system into a more accessible, affordable, and equitable system. So, the AB133 covers a whole number of different areas that we're not going to go into today. But what we are going to focus on is one segment of that, which is section 364 of AB133, which basically does 2 things. Part of what it does is that California's resource exclusion for decades and decades and decades has been $2,000. And this implements a disregard of $130,000 in non-exempt property for Medi-Cal for a case with 1 family member, and $65,000 for each additional household member up to 10 family members. And we're going to get into this more in detail. This subdivision shall be implemented no later than July 1st in 2022, and that has already happened. Now, the second phase of this is that the department will seek federal authority to disregard all resources, meaning that we will have no resource limitation whatsoever, and that's to happen no sooner than January 1st, 2024. Now, the word on the street is that this is a done deal already, but of course we need to wait to get confirmation of that. So what is the significance of AB133? So this all seems pretty simple, huh? As I like to say, simple and disability are 2 words that seldom go together. As we explore this deeper, I'm hoping that you will learn the opportunities this presents, as well as the challenges. To explore the different dimensions of this change, we put together a work group of leading colleagues who will be sharing their perspectives on AB133. So consider this when you're dealing with settlements for a potential client here. Many courts currently have long waits for hearing dates here. We're now getting hearing dates, and we're recording this in March. We're getting hearing dates into August in many jurisdictions. The petition that you filed today could have the right answer when you filed it, but by the time your case is heard, AB133 may have given us a better option. So for many of us, AB133 is in place today. So Why does the Golden State Pooled Trust do free MCLE programs like this? Well, the Golden State Pooled Trust self-settle programs require that every potential beneficiary have independent counsel to ensure that every potential beneficiary has knowledgeable advisement prior to making a decision about whether to join the Golden State Pooled Trust or engage in other options. Traditionally, and we're going to see where maybe some changes are coming up, once you're into the traditional D4A or D4C trust, really there's no room for remorse or to change your mind because there is a lien for any Medi-Cal you use from the first dollar of Medi-Cal you have ever used upon earlier termination or upon death. What we're going to learn is this may give us other options for some of our clients. We want to ensure that beneficiaries understand the nature of what they're signing through independent counsel, and we believe that it's essential for professionals assisting persons with disabilities and seniors to have up-to-date information to assist their clients to best serve their clients and their community. We invite you to explore our current trainings, and if you'd like to be on our mailing list for future programs, once again, please email amy@gspt. Here's just a list of some of the programs currently available, and you might notice that some of them deal with benefits, and some of them just deal with what we consider essentials of disability planning, things that a planner ought to know if they're serving the disability community. Now, in order to put this program together, we wanted to get the input from different professionals. So we put together this work group, of which many of them you're going to see in this program, who advised with us and helped us explore the different options and the different opportunities that AB 133 presents us. So, anyway, I'll be introducing each of these folks as time goes on. Our first segment is going to be from Ann Kerner from National Care Advisors here. And Ann is the founder of National Care Advisors, which was founded in 2008 as a firm dedicated to providing consulting services for attorneys, financial planners, and trustees that support individuals with special needs and their families. We wanted to begin first with Ann as we go through this, because as we look at the different options here about what is best for our clients, part of this is we need to really oftentimes look at the value of the benefits we're preserving. As I like to say, it doesn't make sense to spend thousands of dollars to preserve hundreds of dollars worth of benefits. And so not just with AB 133, but the best practice should almost always be to partner with a care manager that can help us understand what is the value of the benefits that we're looking at preserving here, and maybe some other options that we may not consider. And I want to thank you so much for joining us today, and I'm looking forward to what you're going to share with us on your perspective about care management here and how that might affect us when we're trying to implement options for folks after AB 133.
Thank you, Steve. My name is Ann Kerner, and I am the president and founder of National Care Advisors. We provide special needs consulting and case management services throughout California and the rest of the nation. Our nurses and our education consultants are very involved in assisting clients of all ages with benefits, quantifying the value of those benefits, and making sure that all possible resources are available to achieve their quality of life. Today, I'd like to talk to you a little bit about the new AB 133, which affects the eligibility criteria for Medi-Cal in California. So today we're going to talk about AB 133 and the impacts on proactive quality of life planning. So just to give a little refresher on AB 133, AB 133 is a new legislation that is very specific to the state of California. It does not apply to any other states in the United States. In layman's terms, by 2024, it will eliminate the asset eligibility criteria for most California Medi-Cal benefits program, including in-home support services and facility-based Medi-Cal. This is obviously a big change. The income restriction will remain a factor for eligibility for the following: all Medi-Cal programs, the federal supplemental security income program through Social Security, Calfresh, the nutrition program in California, Section 8 and housing assistance, and energy assistance programs. In addition, there may be some other nonprofit programs that do have asset and income restriction, and it's important to understand those as well. And we'll talk through that in this presentation. I want to kind of start with an overview for the best practices in quality of life planning. And this is the first step that needs to be done prior to consulting with an attorney or a financial planner relative to developing a special needs plan for an individual with either special needs or elder care situations. The very first step within the best practices is to work with the client and their family to define the vision for care and quality of life. That means not the practitioner or the professional's vision, but the client and the family's vision. So where do they want to live? Who do they want to provide care for them? What is their vision over time as family members age, as the client ages? What are they going to do all day? Who's going to provide transportation? All of those things, all of the key elements that are essential to providing quality of life for an individual that needs assistance from another. The next step is to analyze the costs related to that vision. So once we've helped the family and the client develop their vision and we've put it into an organized format, the next step is to go through line by line and to figure out what are the actual costs that are related to that quality of life plan. As we're figuring out those costs in today's dollars, our third step is to identify the payer sources that are available to that particular individual to provide for those costs. And to keep this simple, there really are only 3 ways to implement a quality of life plan. The first is unpaid family time, energy, and love. The second is third-party benefits. And the last is private family funding. If you skip over this step, then I guarantee that your legal documents and your financial plan will not be as accurate as it could be. And so it's very important that we understand exactly the configuration of sources that are available to an individual to actually accomplish their goal for quality of life. The next step after we've done that initial analysis is to look at the key life transition time periods. As many of you are aware, the benefits that are available in childhood are different than those benefits that might be available after age 18 when an individual becomes an adult. And then, of course, once parents age and retire or become disabled or deceased, there can be another change in the value of benefits. So we want to take a look at the value of benefits over the entire lifetime, not just as it stands today. We feel at National Care Advisors that it's important to document the plan and the cost projections, and then to set up a process so that the family and the client can review that plan annually. If there are major changes, for example, a change in the value of the benefit, or a change in the ability of family to provide services on an unpaid basis, that plan can then be updated, and we're never more than a year out of current. This update of the plan can be done with or without other professionals or even National Care Advisors. Certainly the family in many cases is able to do that. And then they can determine whether they need to re-involve their attorney or their financial plan manager based on what changes they may identify. Once we've developed the overall quality of life plan or the comprehensive quality of life plan, then we want to make sure that we're bringing in the appropriate skilled legal services to create the documents that will ensure that the plan is actually followed and that preservation of access to important third-party benefits is maintained. We also want to make sure that we're discussing the plan and obtaining appropriate financial planning services to ensure that private money is provided consistent with the plan. And it's very important that both the legal services and the financial planning services professionals have experience with special needs individuals and knowledge of the eligibility criteria for third-party benefits. And then one of the last items in a quality of life plan is our recommendation that it's very important to share the plan with successors. By successors, I mean those family members, friends, important individuals in the client's life that are going to continue to work with them to make sure that that quality of life plan is actually implemented. So, again, when we're talking about AB133, what's important is to understand what is the vision for quality of life and what is the impact of preserving Medi-Cal benefits for that individual. So what's the value of those Medi-Cal benefits? Does it make sense to do some legal planning, trust documents, other types of tools that we have to preserve eligibility for Medi-Cal relative and specific to the quality of life vision for that individual? So as I mentioned before, it's important for a professional to work with the family to create the vision because we want to talk about diagnosis, potential complications, and what does this individual's care needs look like over their life expectancy. This planning is not just about today. It is for the life expectancy of the client that needs assistance to achieve their quality of life. So that's very, very important piece of the vision. And often we find that parents, family members, and the client themselves are not in a position to be able to objectively project what the future may bring. Another important component of defining the vision are what are the nice to haves and what are the gotta haves. And often as we're working through with the family to create their quality of life plan and the client's quality of life plan, we find that the numbers start to do the talking. So we may start out with a plan that is absolutely reflects what the client and the family want to accomplish. But then when we start to put the costs to the line items, and we look at the potential payer sources, we have to adjust that quality of life plan to the reality of the resources available to accomplish it. The essential components of a quality of life plan, and again, all of this needs to be done before you start to put together your legal documents or make a determination of whether you want to preserve Medi-Cal or not. These essential components include medical care, obviously, custodial, personal care, that long-term care that we always talk about, supplies and equipment, vocational support, transportation, housing, socialization support, and specific quality of life factors. To be honest with you, as a special needs nurse case manager, I have to tell you that the medical care piece is actually one of the easiest to find resources for since we now have the Affordable Care Act. We have access to health insurance for pretty much everyone in the United States today. It is very rare for us to not be able to find a source for health insurance for individuals. The more challenging aspects of a quality of life plan are usually socialization support, specific quality of life factors, certainly housing here in California, and some of the more soft aspects of a quality of life plan. So again, accomplishing that vision, there's only 3 sources. And sometimes I think that we all make this a little, as professionals, we make this a little tougher than it needs to be. There's really only 3 ways to accomplish a quality of life plan. Third-party benefits, in most cases, are important for many reasons, not only because of the funds they provide, but they provide eligibility sometimes for other socialization programs and opportunities to participate. you have to have SSI, for example, or you must be eligible for Medi-Cal in order to do certain types of activities. So it's important to understand on a comprehensive basis what adds quality to that plan for the individual. Also, it's very important to make a look at unpaid family time and energy over lifetime of the actual individual with special needs. As mom and dad age, um, oftentimes those successor family members that will be taking over do not have that same family time and energy to provide care, supervision, support, financial management on an unpaid basis. So here's the timeline. And as you go through, depending on what age your client is, it is possible to absolutely analyze the value of Medi-Cal for that individual. Certainly during childhood, sometimes that will be not particularly important. Medi-Cal is not providing a lot of benefits and perhaps is not a huge factor in achieving the quality of life plan that the parents have for their minor child. After age 18, of course, Medi-Cal sometimes can be much more valuable to that individual because mom and dad's income and assets or income is no longer a factor. And so we want to make sure that we quantify that value. And then at the end of life, when we're talking end of life care, when it might be necessary for skilled nursing or skilled nursing facility care, we want to make sure that we really have quantified the value of Medi-Cal at that point and whether it makes sense to preserve access to Medi-Cal. So while the asset test is going to be removed for Medi-Cal eligibility, as I mentioned previously, there are still going to be other benefits that remain with criteria that include an asset test, and that includes certainly supplemental security income. Certainly there are VA benefits as well. There's other government benefits that I talked about, and then nonprofit resources. I'm going to go into a little more detail on some of those benefits. So the potential value of benefits, just to do a little refresher, this is for 2022, these figures. But in California, the maximum supplemental security income, assuming that you haven't had a 1/3 reduction for deeming or providing support for housing, utilities, and food, is $1,041.21 per month. That includes the state of California supplement. So the value to the individual is $12,494 per year. Not an insignificant sum for most of the clients that we work with, but still, it's important to understand what that number is if you want to turn your back on supplemental security income, which will continue to have an asset test. Right now, that asset test is an individual can't have more than $2,000 in their name. Supplemental security income does not have a significant restriction on housing. In most cases, we can have a pretty nice house and not interfere with our supplemental security income as long as it's the primary residence. But the bigger problem for most of our clients when we're considering whether or not supplemental security income is important is the restriction on other assets. Calfresh, this is nutrition support, so essentially the old-fashioned food stamps. This is important to quantify based on the household size, often because they're going to look at household income. So if we have a special needs individual living in a household, they have significant income, but there are others in the family that do not have that same level of income. You could be interfering with the nutritional support for the entire family if you decide to not preserve access through sheltering assets. So the Calfresh benefit for a 2-person household, this is just an example, maximize out at $459 a month for a 2-person household, or $5,508 per year. We often have multi-generational families in a home. We can have many children, minor children, as well as other individuals who might be elderly or have other needs. And so it's important to understand that before you decide if you're going to, if that new asset criteria for Medi-Cal is something that will change the plan. The Medicare Savings Plan is also a benefit that has significant value to many of our clients. Medicare savings plans are for individuals that have relatively low income, and it also has an asset test. It will pay the Medicare Part B premium. It'll pay for copays and deductibles. And that Medicare Part B premium is a minimum of $170.10 per month. If you have a client with Medicare, it's really important to quantify what their Medicare Part B premium is now. It starts at $170 a month. But if they have significant income, it is going to be much higher than that. It is now on a sliding scale. And so we are seeing very high Medicare Part B premiums. And so it's important to understand what that is. These Medicare savings plans still have an asset test as well as an income test. But if you have someone who's dual eligible, both Medicare and Medi-Cal, we really want to understand that before we decide to, again, change the financial plan for that individual relative to AB 133. And then the last example that I wanted to give regarding the value of benefits is Section 8 and HUD. Again, this is often a household income situation, an asset situation. Section 8 can potentially reduce the living expenses for a family up to 30% of the household or the client's income. And that's important to understand. If that's in play for the client's home because they're living with extended family members or they've traditionally always had Section 8, you want to understand that before you complete your planning relative to AB 133. As in all cases with either elder care or special needs, it's all about the custodial care piece. That is the most expensive line item in any quality of life plan. And it's super important to understand the value of means-tested benefits for not only the individual, but also for the family that's supporting that individual. So the Medi-Cal programs that are important to us are, of course, in-home support services. The max is out at about 283 hours per month of aid level care in the home for an individual. Has a huge value when you're looking at a quality of life plan. There are home and community-based services waivers also available for individuals who have very skilled and acute nursing care needs. So, for example, someone's home with a ventilator or has a lot of suctioning requirements, a tracheostomy, those types of very skilled nursing services rather than custodial care. There's the basic state Medi-Cal program that covers, of course, doctors and medications and equipment and lab work and hospitalizations. And then at end of life, we're usually very concerned about facility-based Medi-Cal and the value that that brings if an individual family cannot maintain their loved one at home and they need to transition to a skilled nursing facility for very end of life care. Super important to understand that AB 133 does not change the income requirement for eligibility, only the asset requirement. It would seem on a common sense level that if you have a lot of assets, you're going to want to invest them so that they will produce income. And so that's all part of that discussion with the financial planner and then ultimately the attorney as well, as whether it still makes sense to shelter income to preserve access to these Medi-Cal programs for the individual client. So as I mentioned before, these Medicare Savings Assistance Programs are important. They're federal. They are not California specific, and there's still a restriction of assets for these valuable benefits. And so it's important to understand if that's in play for your client. I can't stress that enough. We often see that these programs are missed, and we're spending a lot of money on supplemental Medicare insurance and or other types of benefits when we don't have to. Now, on the other side, we do also see here in the state of California that we have a lot of very good Medicare Advantage plans that are zero premium. So we want to understand those and actually quantify the benefit as part of the plan, not just guess at it before we make the decision of whether we want to preserve access to these Medicare savings programs. As I said before, there is still an asset test for these programs. This is especially important for relatively low-income elderly clients that may have assets. It's also important to understand if a client is receiving Veterans Administration benefits. There are many valuable programs within the VA for home care assisted living, and skilled nursing facilities care. And these benefits do have both an income and asset restriction for eligibility. Now, one of the things that we know about the Veterans Administration, it depends on where the veteran served, what was their length of time in service, did they see active duty during wartime or peacetime, and where did they serve? So it's not easy to just assume what the Veteran Administration benefits will be. We have often found that we have some pretty significant VA benefits for home care and assisted living facility care, and I guarantee you there's an income and asset restriction for those services. There are other benefits that may have significant value, and again, as I said before, for the household. It is very easy for some of us as professionals to just want to look at the client as if they live all by themselves. And the reality is that it's pretty rare to have a client that doesn't have a family household that's assisting them in some way. And so it's so important to understand the entire family situation and financial situation, not just the individual. So the dream team of collaborative practice to do any type of special needs, consulting, recommendations, legal work, financial planning, has to include these individuals, I believe. That is, first of all, to actually get that vision defined, make sure it's documented in some type of an organized format. And the special needs consultant or case manager is really the bridge between the family and the client, and the law work, the legal work, the financial work, the benefits, and the quality of life vision implementation over life. I see the special needs attorney or the estate planning attorney as the quarterback, and that individual should have a lifeline consultation and legal support for that client and for that quality of life plan to make sure that the documents that are created are current and that they will actually support and enable that client to achieve their vision for quality of life. Obviously, the financial and investment advisor is key to making sure that we have funding and that all resources are considered. And then in the event that we need a trust is recommended, or some type of shelter for funds, or to assist with the management of funds, we want to make sure that we have a trustee that really knows what they're doing relative to special needs considerations. So this change in the eligibility criteria for the California Medi-Cal program actually increases the need for collaborative practice and the analysis of the value of Medi-Cal specific to the individual client's lifetime. I cannot stress enough that the most effective legal and financial strategies for creating and implementing a special needs or elder care quality of life plan must include this data. It's impossible for a lawyer to do their job or a financial planner to do their job if we have not done the first part, which is to define the vision of what needs to be accomplished. I appreciate your time. I hope that you have found this information helpful to your practice, and thank you so much.
Thank you, Anne. As a takeaway, as a best practice in any planning situation, I find a care management evaluation absolutely invaluable. AB133 heightens this need to help planners determine what are the best options for a particular situation. But before we go to our next perspective, let's give out our first MCLE code. So code number 1 is 5824. And once again, for those of you that are watching this program here, you should write down this code, and then you're going to need to enter it into the proper form, which you can find by going to gspt.org/attorney resources. So for our next perspective, we have Gene Osowski, who's the founder and principal of Osowski Law, which focuses on elder law, estate planning, Medi-Cal planning, special needs planning, and trust administration. He derives a great amount of his personal and professional satisfaction by protecting seniors and their loved ones from the expense, frustration, and stress associated with incapacity and long-term health care. Hey, Gene, can you fill us in on your perspective on how the change in resource rules in California are likely to affect an elder law practice?
Well, thank you, Steve. I'm happy to be here to join you in this presentation. As you indicated, my name is Gene Osofsky. A little comment about myself. My focus is primarily on helping seniors, we call them elders, plan for and access the long-term care system. And I've been doing this probably for about 3 decades in the Bay Area. So I'm still learning, and new things are happening all the time. And the most recent, of course, is AB133, which I'm going to talk about today. So the name of the presentation is AB133, What Will Change, What Will Remain the Same? And by the way, it's probably evident that AB133 refers to legislation, namely the governor's State of the Budget bill that he signed in July of 2021. And a very small part of that, but a very important part of that, had to do with changes in Medi-Cal. And that's what we're going to talk about. So the first part is what will change. Essentially, in a few words, the Medi-Cal resource requirements are to be eased and then eliminated entirely. Now that's very dramatic, eliminated entirely. And we'll get into that. The budget bill makes the change to the Welfare and Institutions Code as indicated, and we'll talk about that. So the change is going to occur in 2 stages. The first stage is going to be effective July 1, 2022, and the second stage is going to be effective a couple of years later, almost a couple of years, on January 1, 2024. So let's talk about stage 1. Stage 1, remember, is just a few months away. It's going to be effective July 1 of 2022. So as of that date, the Medi-Cal applicant, anybody applying for Medi-Cal, can have $130,000 in countable resources plus $65,000 for each additional family member in his or her household who is not also applying for Medi-Cal. Now, how does this compare with what we had before? Before, a single unmarried individual could not have resources in excess of $2,000. So this is a dramatic increase. Now, what if the applicant is married? Well, if the applicant is married and his or her spouse does not also seek a Medi-Cal subsidy and is not in a skilled nursing facility, the spouse can have an additional $137,400. $137,400. This is called the Community Spouse Resource Allowance. We usually refer to it by an acronym, CSRA. The CSRA changes every year. It's indexed to inflation, and it generally, in my experience over the last umpteen years, increases every year. So what does this mean? A married applicant with a community spouse who's not also applying for Medi-Cal can have the sum of $137,000 for himself and $137,400 for his or her community spouse. Together, that's $267,400, more than $250,000 in the bank. Now, how does that compare if each spouse applies for Medi-Cal? Now, this happens occasionally. If that happens, each spouse would be entitled to $130,000 for a total of $260,000. Formerly, it would have been $2,000 apiece. So this is a dramatic increase. And in the PowerPoint, I've cited the Implementing All-County Welfare Directors Letter, which came out November 19, 2021. So it's really a done deal. It's really set to go. We just have to look at the calendar, and it'll take effect. So that's stage 1. What about stage 2? Well, stage 2 will occur on or about January 1, 2024, and that's when the resource caps end entirely. Now, this is going to be subject to federal approval, but my sources tell me, or if you will, word on the street is the feds have already approved it, or will approve it, and this is, if you will, a done deal. So California is the only state in the country that proposes to abandon and eliminate entirely all resource requirements for those applying for what the rest of the country calls Medicaid and what we in California call Medi-Cal. Now, it remains to be seen what the implications of this will be. I predict that California will be a mecca for elderly retirees. And there's also in this AB133 a bonus to immigrants. There's going to be there are two age groups referenced in the legislation. And they're both going to be granted Medi-Cal, even if their immigration status is unsatisfactory. Those younger than age 25, actually that's already in effect. And effective July 1 of 2022, those over age 50 will both be eligible for Medi-Cal, even if they have an quote-unquote unsatisfactory immigration status. Now that leaves out those between age 25 and 50. I don't know why they were left out, but so be it. And this again amends the Welfare and Institutions Code as indicated. Well, let's talk about what has not changed. And this, in talking about this, I'm addressing this to those in the audience or viewing this who primarily work with seniors, and of course to my elder law colleagues. So I've made a list of everything that I could think of that doesn't change. And the top of the list is the income rules. We'll talk about that shortly. Next is estate recovery rules. Next is gift penalty rules. And something I call quote-unquote conventional estate planning. And the special needs trust rules don't change dramatically. The administration of existing trusts doesn't change. In other words, the legislation is not retroactive. Same with third-party trusts. And of course, the SSI rules, which are federal rules, don't change by the California legislation. So SSI rules remain the same. So let's talk about the income rules. This is very important. There are a few key components. Many of you in the audience will probably recognize this. The first is what we call the spousal impoverishment income rules. And basically, years ago, Congress decided that if, let's say, the husband needed Medi-Cal and needed to go into a nursing home, Congress didn't want to impoverish the at-home spouse. They wanted to provide the at-home spouse with sufficient income so that he or she, let's call it she, could go to the grocery store, pay her bills, pay utility bills, and live a decent life in the community. So, from their combined income, the at-home spouse was allowed to keep what Congress called the minimum monthly maintenance needs allowance, and we use the acronym MMMNA, which we in California pronounce as EMNA. Now that's going to be applied in the same manner. So, currently, remember I said it changes every year, it's indexed to inflation. The current EMNA is $3,435, 3435. And that will affect the nursing home spouse in this manner, that if the at-home spouse does not have enough income in her own name to reach her entitlement to the EMNA, she can borrow, if you will, from the income of the nursing home spouse. That's called a spousal allocation. And the effect of that is to reduce the income of the nursing home spouse, and the corollary is reduce his share of cost, which goes toward his Medi-Cal, goes toward his long-term care. So, making up the spousal allocation to make sure that the at-home spouse has sufficient income up to the EMNA reduces the income as indicated, and it can reduce the income of the ill spouse to an amount below a certain level, which I'll talk about in a moment, and effectively make his Medi-Cal, especially if he's at home, without cost. We call that no share of cost Medi-Cal. And the program that we look to is a federal program called the Aged and Disabled Federal Poverty Level Program. The income cap for a single individual will increase April 1, 2022 to $1,564 per month. So the implication is, if by making the spousal allocation pursuant to the spousal impoverishment rules, the ill spouse's income goes down below $1,564, bingo, if they need care, for example, at home under some of the home and community-based services programs, the waiver programs we call them, then he would be entitled to those programs without a copay, without a share of cost. We will still have strategies that we've long used to reduce share of cost. For example, credit for unpaid medical bills under two leading cases, Johnson versus Rank and Hunt versus Kaiser. We still have strategies available to reduce the income of the ill spouse in the event he wishes to apply for waiver programs or no share of cost Medi-Cal. And by the way, by waiver, we generally mean that the legislation waives the traditional requirement that the ill spouse receive care in an institutional setting, that is, a nursing home. The waiver refers to the fact that he can receive it at home in many cases, or in some cases in an assisted living facility. So waiver refers to waiving the skilled nursing facility venue. So how do we do that? Well, health insurance premiums, Medicare, of course. The Medi-Cal spouse can purchase extra dental insurance, extra vision insurance. Whatever will qualify as a health insurance premium will reduce income, and the goal is to get it under that 1564 number that I mentioned previously. We still will have strategies to increase the income of the community spouse via court proceedings under Probate Code Section 3101, in family law proceedings by a complaint for support under Family Law Section 4303 as indicated. And something that's not really been used to my knowledge in California is something called a quadro. Quadro is spelled, it's an acronym, it's spelled QDRO, and the full name is Qualified Domestic Relations Order. And it pertains to ERISA plans, 401k, 403b, things of that nature, not IRAs, ERISA plans. And there is a procedure to change ownership of these plans, whether or not there is a divorce pending, so that it goes from the ill spouse to the well spouse, and by doing so, the income stream would change. Let's say there's an income stream because RMDs, or required minimum distributions, are paid out. The income stream goes from the ill spouse, which would only increase his income and correspondingly his share of cost, to the at-home spouse, and then supplement her MNA, minimum monthly maintenance needs allowance, and or even if she's beyond that, she would be allowed to keep it under the so-called name on the check rule. So this is something that I predict will become in greater use in the future after AB 133 is fully implemented. What about estate recovery? Well, the good news, bad news, it'll still exist. There's no current change pending permitting any difference in estate recovery, so long as there is a probate estate. How do you avoid probate, of course? Well, you have things like a living trust, pay on death accounts, transfer on death accounts, joint tenancy accounts, accounts with beneficiary designations, etc., etc. If planning has taken place, and we as elder law attorneys can still assist our clients with this kind of planning, if there's not to be a formal probate on the death of the decedent, there will not be any recovery. Now, this is in addition to the other exceptions. For example, if the decedent is survived by a surviving spouse, no recovery. If this decedent is survived by a disabled child, no recovery. But, there's a very big but. If you can see the screen, look at the bottom. Legislation was just introduced in Congress to basically free up each state so that each state could on its own decide that they're not going to pursue Medicaid, or in our case, Medi-Cal Recovery. We don't know the effect of this legislation yet. It's called H.R. 6698, but it's something to watch. So it's possible that a state recovery, even for probate states, will go by the boards. Okay, what about gift transfer rules? Well, they're going to still exist, but gifting is going to become easier. And by gifting, I mean where the Medi-Cal applicant gifts some of his or her funds to somebody else. Typically, it's to a child. Could be to a friend. All in order to qualify by meeting the resource caps. So let me tell you in what respect it's going to be easier. Well, let's suppose we have an unmarried Medi-Cal applicant with $130,000 in the bank in countable resources. And remember, that's going to be the cap as of July 1, 2022. Let's say he makes a gift of $100,000 to his child. From that $130,000, there's not going to be any penalty. Why? Because he's essentially gifted what would otherwise be exempt funds. The gifting does not accelerate his eligibility for Medi-Cal. Now, for people who have more than that and want to gift more than what the exemption is, there will still be room for gifting strategies to transfer funds beyond those resource caps. And as elder law attorneys, we've used gifting strategies for years. We call them by different names. I call them sequential gifting in amounts under the average private pay rate. There's something called half-a-loaf gifting, and there are other gifting strategies that we've used for years. I predict those are still going to be available, certainly until the caps are eliminated entirely in about 2.5 years. After January 1, 2024, there will likely be no more gifting penalties, but we're awaiting official pronouncement from the Department of Health Care Services. Essentially, we're looking for an all-county welfare directive letter to confirm that. Okay, what about, remember I said, in my view, estate planning as we've come to know it, especially planning for our clients who are thinking about long-term care issues and are elderly, that's going to remain pretty much the same in this respect. I've listed, I don't know, half a dozen different things that we'll continue to be mindful about and continue to incorporate in our plans. For example, we'll all want to address incapacity and the ability to delegate authority under the estate planning documents that we draft for our clients. We want them to be able to manage trust assets even after they're incapacitated, and if necessary, modify the terms of the trust. For example, if tax laws have changed or if public benefits laws change. We'll want our documents to permit the creation of a third-party special needs trust in the event there's a bequest to a beneficiary who has become disabled and would otherwise qualify for public benefits. We still will likely want to use trust protectors, including the power to change situs of trust administration. We still will want to include decanting powers in our documents, or at least not to preclude them. I'm going to skip down, and we'll still have tax planning considerations. For example, we will still want to preserve the Internal Revenue Code Section 121 exclusion in the event of a home sale, the $250,000 per person exclusion for a home sale, and we'll want our planning to preserve the step-up in basis of appreciated assets. Now, I skipped over something. I've called it the Testamentary Trust for the Surviving Spouse. Now, what's that? Well, under existing planning, when we're planning for a married couple, many of us include in our plans what we call a testamentary special needs trust for the survivor in the event the survivor is then a Medi-Cal recipient and in a nursing facility. Well, you might say, why do we need to do that, especially after January 2024 when there are not going to be any resource tests? Well, the answer, because income still counts. Let's suppose we have a surviving spouse after January 1 of 2024, and let's say it's a she, no disrespect intended, and she is entitled to income distributions and is also on Medi-Cal. If she's in a nursing facility, why does she need additional income? In other words, if if her own income from Social Security is, let's say, $500 a month, and that would essentially be her share of cost. But if she has access to income from the Special Needs Trust, that would bump her to, say, $1,500, that money just increases her share of cost, goes down the drain, if you will, and does not stay in the trust for the ultimate benefit of the downstream beneficiaries of the couple, typically the children. So I think there is a place for that planning to still remain in effect because of the income issues. There's not going to be any change in the rules regarding special needs trusts, and they still may be used to enable Medi-Cal eligibility by sheltering resources above the cap until resources are completely eliminated on January 1, 2024. Afterwards, there are going to be new strategies available to shelter income, and I believe other speakers are going to address that. But SNTs, Special Needs Trusts, will still be valuable to manage funds for beneficiaries incapable of managing their own funds and beneficiaries wishing to remain on SSI, and possibly beneficiaries living in other states. And in this respect, I think other presenters will be discussing these issues. Just a word about ABLE accounts. If the goal is to preserve Medi-Cal and comply with the resource caps, they're still going to be useful to shelter funds until January 1 of 2024, when we anticipate the resource caps are going to be lifted entirely. So after that, if the goal is to maintain Medi-Cal, ABLE accounts won't be necessary to shelter resources, but they will still be useful to preserve SSI and for money management issues for those beneficiaries who need money management. So I thank you for your attention. I hope I didn't go too quickly. And here's a slide from part of my website. Again, thank you for your attention, and thanks to Steve Dale, actually, for putting all this together. Be well, take care of our elders, and Godspeed.
So for those of you that are taking this for MCLE credit, code number 2 is 9035. That is 9035. Hi, this is Steve Dale. And for this segment, we're going to talk about investments and income. So to do that, we're going to need to get back to basics a bit. For any of us who've been doing planning for any length of time, OBRA 93 has basically been our Bible, which sets out several rules. And if you break those rules, the corpus is counted as a resource. So under D4A, we all should know that it has to be for somebody under the age of 65, that there's a payback upon earlier termination or death. For a D4C or pooled trusts, it must be run by a charity and can be for somebody over the age of 65. And there's a payback for either earlier termination or death for the funds that are not retained by the trust. So what if we break those rules? Well, during the first phase under AB133, if the corpus of the trust is less than $130,000 between July 2022 until sometime after 2024, we should be fine. And after 2024, the resource rules don't count at all, so we don't care about the resource rules. So this is going to take a little bit of adjustment for many of us who are looking at using this strategy. If all we care about is the Medi-Cal, then we don't need a payback or an early termination clause. And age doesn't matter. Even so, the income rules still apply. So let's review the income rules under Medi-Cal. So we're going to start off with Title 22, Section 50501 under the California Code of Regulations. Okay, so under 50501, income includes benefits in cash or in kind from labor, services provided, business activities, returns from real estate property, contributions, or similar sources. But this is what's key. Income from sources listed in A shall be considered as income only if it's currently available in accordance with sections 50513 through 50517. So let's see what that says. Also, income from sources listed in A shall be divided into three types. So gross income, as described in section 50503 under Title 22, or gross unearned income, as described in section 50507, or income in kind, as described in section 50509. Now, I won't go through all the different types of income under 50507, but I highlighted a couple of things that are pretty common. So when we're looking at countable income, that's going to include most Social Security benefits, annuities that are sums yearly paid, or at other specific intervals in return for payment of a fixed sum by an annuitant, disability payments with the exception of disability insurance here, gifts, inheritance in the form of cash or securities or liquid assets, contributions from any source, dividends, which will be key to the rest of this presentation, and interest payments from any source, including trust deeds and contracts of sales. Great. So now, the other income here for Medi-Cal is one that's sometimes hard to really understand. So let's go through that. Under Title 22, 50509A, it says that income in kind of any support or maintenance received in kind from any person other than a responsible relative, and that could include a trust, for housing, utilities, or food. And it says clothing, but the clothing requirement has been dropped, is going to be income, but it's only counted as income in kind if the entire item of need is provided. So now here's a graph of what happens in that case. And this hasn't changed in a number of years. So for instance, if you have a single person, and let's say you paid the entire rent, they would add $153 to your countable income, no matter how much you paid for the rent. The same thing for the utilities, which would be to add $33 if all utilities were paid by an outside individual, including a trust. And food would be $86 if the entire item would be paid. So let's see how this plays out. So let's say Barbara wants her Golden State Pool Trust account to pay her rent for $1,000 a month. Barbara receives $1,500 a month in Social Security disability insurance, which we've already seen is going to be countable income. She also receives aged and disabled federal poverty level Medi-Cal. So if the Golden State Pool Trust pays her full $1,000, then her countable income would be $1,500 plus the $153 we saw from the table, which makes her countable income $1,653. Since $1,653 is greater than the $1,564 limit under the Aged and Disabled Federal Poverty Level Medi-Cal Program beginning April 1st, 2022, she will have a share of cost of $1,053, which is basically her $1,653 minus $600. Well, that's not a very good result. If she were to pay any amount, even a nominal amount, let's say she pays $20 in this case towards her rent here, and then the remaining $980 was paid from the trust, then she would have no countable income, and it would not affect her eligibility. So how does this play out under AB 133? Well, let's talk about how does investment income affect AB 133 and how does it affect benefits. So in this example, let's say Bob is disabled and receives 283 hours a month of IHSS under the Aged and Disabled Federal Poverty Level Program. He's receiving $1,000 a month of SSDI and no other income. On August 2022, he gets an inheritance of $100,000. Under AB 133, if he just holds it in his own name, he can invest the funds, but if he realizes more than $564 a month of interest income from the dividends, which is basically, if you put that out on a yearly basis, that would be $5,772 a year, or a 5.7% return of investment income here, it will throw him into share of cost because, once again, the amount is greater than what is allowed in 2022. Let's say instead Bob receives $1 million after 2024. Once again, he could hold it in his own name, and he can invest the funds, but if he realizes more than $564 a month, once again, our same number, or in this case, this would be just a hair over 0.5% return of investment income, it's going to throw him into share of cost. So the answer really for Bob is to put the funds in an irrevocable trust here where the trustee has sole and absolute discretion, so he doesn't have access to the income here. And so with irrevocable trust, once again, under Title 22, Section 50501, it says that income shall be considered income only if it's currently available. So the trust basically can trap the income here as long as it is not immediately accessible by Bob. Therefore, if the funds are placed in an irrevocable trust and Bob does not have access to the income directly, then any investment income will not affect Bob. Distributions in kind are not income, with the exception of our 50509 example here, as long as things are paid in kind, just like any other special needs trust. So if we have an irrevocable trust where the income is not available to him and the trustee has sole and absolute discretion of all the distributions, and all distributions are made in kind, Bob does not realize the investment income for Medi-Cal purposes, nor does he receive benefits income so long as we don't run afoul of Section 50509. Now let's take a minute and talk about capital growth. Remember, from July 2022 until 2024, care needs to be made to make sure that the corpus of the trust or the assets available to Bob do not exceed $130,000. Until 2024, you could invest in a capital growth fund, but there could be a danger that going over the $130,000 cap in 2024 could be problematic. Capital gains does not really become income until there's a taxable event, usually the sale of whatever the asset is, but unrealized gain could still raise the value of the investments over the $130,000 resource limit. So in this example, let's say July 2022, Bob receives $120,000 and invests the funds in a capital growth fund. The funds are invested and grows in value by 10% or $12,000, making the entire investment worth $132,000. Until 2024, the unrealized gain will still have the effect of increasing the value to over $130,000, causing Bob to be over-resourced until 2024. So once again, this is why you need to work really closely with your investment advisor whether you hold it in your name or hold it in a Medi-Cal Preservation Trust here, because you have to have care at least until 2024 not to have the funds either available to Bob or held by the trust to go over $130,000. By the way, Tanis will cover some strategies using a structure here where we might be able to handle longer cases as well. So let's talk for a minute about capital gains as income. If Bob owns the investments outright and sells $20,000 of the investments, for instance, to buy a wheelchair, he will realize that $12,000 of gain, which will be counted as income for benefits purposes. If the investments are in a Medi-Cal Preservation Trust, and the Medi-Cal Preservation Trust purchased the wheelchair and gives it to Bob, then he will not receive income for Medi-Cal eligibility purposes. Anyway, I want to thank you today for listening to me here about how investments and income affect a person on aged and disabled federal poverty level Medi-Cal after AB 133. So our next presenter is Phil Linsley, who's widely recognized in the area of elder law and disability planning. Phil's also a state bar certified legal specialist in estate planning, trust, and probate law, and an accredited Veterans Administration attorney. His practice is limited to Medi-Cal, VA, and asset protection planning, special needs planning, estate planning, and conservatorship alternatives, as well as life planning and probate and estate administration. He also works with his wife, Liz, and they actually do applications for Medi-Cal. So anyway, Phil, I'm so excited to have you here today to share your perspectives about how AB 133 is likely to affect an estate planning and special needs trust practice.
Well, thank you, Steve. This is Phil Linsley speaking to you on AB 133, how this affects Medi-Cal planning. I thank Steve for the nice introduction. If anybody wants to know a little bit more about the Vitae, here's a little blurb. So let's get rolling. What is AB 133? Well, we've all probably heard about the effect of Medi-Cal asset tests, but it's more than that. There's some significant changes to the delivery of healthcare services that are part of this bill as well. A program called CalAIM that's going to be implemented between 2022 and 2027, implementing something known as enhanced care management. We are not going to talk about that today, but stay tuned. There's a lot to come from that. Cal MediConnect, the dual eligible program, will be ending this year as they roll out parts of this to take its place. It's also going to have significant effect on the various HCBS programs, but again, not today. We are going to focus on the Medi-Cal asset rules. Now this, as other speakers have mentioned, has a two-phase implementation. On July 1st of this year, 2022, we have a new personal exemption of $130,000. That's done. That's a done deal. It's been approved by CMS as part of our alteration to our state plan. The second phase is the proposed abolishment of any asset test. The obvious intent behind there is to make everything like Magi Medi-Cal, which is no asset test, just income test. Make it all uniform. That has not been approved yet by CMS. Some people think it's going to be. It's a done deal. Some people not so sure. I just say stay tuned. I don't think it's going to be as big an impact. Certainly, this first phase, I don't think it's going to be an impact on anybody's practice, at least not a negative one. Abolishment of the asset test, it's probably also not going to be as catastrophic as some people who are planners think. So I grabbed this slide right out of my current Medi-Cal presentation. One of the things that's not changing is all the other rules of Medi-Cal. What's exempt? Home, retirement accounts, certain annuities, personal property, not changing. What is changing is over on the right side of your screen there, the non-exempt limits. Currently 2,000 going up to 130 per individual. We'll still have the community spouse resource allowance, so that's 267,400 for a couple. Really, it's 130 for an individual. If there are more people in the family, it's 65,000 for each additional family member. And so that's this slide explains how that works out. Each one of these people is 65 more. It caps out at 10 people as part of the MFBU or Medi-Cal Family Basic Unit. So what's not changing? Well, basically everything else. SSI and other means tested program rules are not changing. So if you have somebody that is on SSI, Calfresh, just about any other means tested program, they have not decided to raise their 2,000 limit up to 130,000. And if you act as if you can have $130,000 for anything other than Medi-Cal, you're going to find yourself disqualified from that program. So also not changing is every other Medi-Cal rule. Spousal impoverishment rules are not changing. Counting of asset rules, other than the new exemption level, not changing. Income rules, unavailability rules, everything you see on this slide. Nothing's changing. Basically, everything is remaining the same except for that $130,000 limit, personal exemption. Now, I have highlighted on this slide income rules, and the reason is not because they're not the same. They also are not changing. But unlike these other things listed here, there are some significant reasons to consider this when we think about how our planning is changing with this new personal exemption level. Special needs trusts are not changing either. Again, nothing else is changing. So this is a good problem to have. It's what they sometimes call a first world problem. What do you do with $130,000? Well, basically that kind of logic hasn't changed either. Now understand, this is a new exemption, so it doesn't matter what you do as far as asset tests. You could plop it in a bank account, and it's not going to affect your eligibility as far as asset tests. That doesn't mean that's the smartest thing to do. That might fit sometimes, but there usually are going to be better, smarter things to do. Your choice is going to be based on the facts of the individual case. Are there capacity issues? Are there spendthrift issues? Is it just basically somebody who would benefit from a fiduciary or somebody else managing the assets of the trust? Whatever the reason is, chances are an irrevocable trust is often going to be the best choice. Now, you have heard that discussed by the other speakers. We're going to take a little closer look at that as well. So if you're going to use a trust, you got to remember OBRA 93. And here is the authority. 42 USC is the federal authority. The rest of these are all citations into Medi-Cal and state authority about how Medi-Cal treats trusts under OBRA 93. That is one of the parts of OBRA 93 that California did adopt. OBRA 93 trusts, as defined, are in California Code of Regulations 5489.5. Other trusts are in 5489.9. Now, OBRA divides the world, it's binary, into two categories: OBRA trusts and other trusts. You need to be aware of this as we contemplate what are the implications of setting up a trust with this $130,000. Refresh you, OBRA 90 trust is a trust created other than by will by an individual or their spouse or somebody acting on their behalf as an agent or a court. And the assets or income in that trust are available under any circumstance to the individual or their spouse. Now, this is in the disjunctive. So if any one of these things are true, you do not have an OBRA-93 trust, you have an other trust. But if all of these are true, you have an OBRA trust. Now, as we can see, this describes most everybody's revocable family trust. It's not created by will, it's created inter vivos. It's funded by the person who's drafting it and whose assets are going into it, and they're the beneficiaries. Bing, OBRA, OBRA-93 trust. So our new trust to hold 130,000, well, whatever we call it, and I've heard it called Medi-Cal Protection Trust, a Medi-Cal Reserve Trust, all sorts of things. I don't know what it's going to be called, but it is clearly an OBRA-93 trust. Assets are available. It's established other than by will by the individual whose money it is, or at least on their behalf with their funds. So it's an OBRA-93 trust. Medi-Cal authority for OBRA and other trusts are here, as I've put forward here. You note, in addition to the California Code of Regulations, I'm a big fan of the Medi-Cal Eligibility Procedure Manual, or MEPM. So I've given you citations to this. If you Google these, they pop right up. And so I've even given page numbers. So you can go and look at these and drill right down on it. And I recommend that you do that. So your other trusts are trusts that are typically established with the assets of a third party or by will. Now, the regulations here, if you go to 5489.9 and look for third party trust, they don't really mention third party trust, but they're there. They're there in the part of it that says, if this is not a trust as defined in 5489.1 or 5, it is a trust, another trust governed by this chapter. So they're there. They're not an MQT and they're not an OBRA trust. So how does Medi-Cal treat trust assets? Well, if it is an OBRA trust, other trusts, such as a third-party trust or a D4A or D4C, they include D4As and D4C under 489.9. So if they're irrevocable, the income is, if it's retained in the trust, is not counted. If you have a distribution, if it's from current income, it counts as income. If it's from principal, it does not. It's counted as an asset. Somebody now has an additional available asset due to that distribution, but not income. And this is why we seldom worry about distributions from special needs trusts, because they're under 5489.9. And it's a presumption that they're distributing from principal. So, and by the way, it might be a tip to make sure that your trusts have a adding of undistributed income into principal. So what about our OBRA-93 trust, though? Well, like our contemplated $130,000 trust, if it's irrevocable, the corpus, since it's available, is counted as an available asset. Every penny of it is counted as an available asset. But that doesn't matter to us, because this is limited to 130,000. Medi-Cal has already said we're not counting $130,000. So we don't have to worry about the fact that an OBRA-93 trust is an available asset. Income, however, what does it say about income? Well, first, retained income is not counted as income, just like the other trusts. And that's good news. That's why it is better to do one of these trusts than it would be to just plop it in a bank account, because income retained in the trust is not going to be counted as income to the person. So, however, Income, whether it's income or principal, if it is actually distributed, it is counted as income to the individual under 589.5. Once more, whether income or principal, it doesn't matter. If there's a distribution, it's counted as income. Now that might matter to us. We're going to take a look at that, see what that means and what possible workarounds there are. So over 93 trust, like our contemplated $130,000 trust, says basically if payments from the trust and income are made for the benefit of the individual or spouse, they shall be considered income in accordance with Chapter 10 of this chapter, Article 10 of this chapter. So I put it there just in case you didn't believe me. There's a citation. But the interesting part of this is the in accordance with Article 10. Now, Article 9, which is where 5589.5 and 0.9 is the chapter on principal and assets. Article 10 is the income rules. So, and hoping maybe there's some enlightenment in Article 10 or something we can is useful to us figuring this out. Let's take a look at Article 10. Now, in Article 10, in 22 CCR 5501C, it says income is divided into 3 types. Gross earned income, and it cites the section that's found in. That's not relevant for what we're talking about with our $130,000 trust. Gross unearned income, as described in 5503. That is relevant. Considering what we just saw about, well, we're counting it whether it's income or principal. That's something to possibly worry about. But the third category that I've highlighted is in-kind income, as described in 5509. So that's what I think is the thread for us to pick up and see where it leads. So what are the Medi-Cal in-kind support rules? Well, they're found at 22 CCR 5509. Income in kind under Medi-Cal rules is any support or maintenance received in kind from a person other than a responsible relative, that is, other than a dependent, for housing, a person taking care of a dependent, housing, utilities, food, and clothing. And utilities under the code also, or at least under the MEPM, clearly mentions telephone as well. Clothing, interestingly enough, it still says that in the regulations, but an all-county welfare director letter came out in 2009 saying that to conform with SSI, we're not counting clothing anymore. So now understand, many of you are familiar with ISM rules from SSI. Medi-Cal's ISM rules are different. The concept's the same. That they are going to count a portion of things distributed to an individual for the ISM categories, potentially count as income. But 5509 has a hole you can drive a tank through. Income in kind shall be considered as income only if the entire item of need is provided. Now, what does that mean? Well, if you are paying for housing and somebody's rent is $1,000 and you only pay $950 or $980 from the trust, you have not paid the entire item of need. If you have not, it is counted at 0. That, as long as you have understanding of this rule and a modicum of discipline and control over these distributions, you should never suffer any kind of income assessment for distributing in Medi-Cal any of these items. As long as you stick to that discipline. And if you don't, you will find that the actual income assessment is small. It's less than $200 for rent. I think it's $79 for food, so it's not a big deal. And it's so easy to avoid altogether. I don't think people ever even really think about it too much. Again, if they know the Medi-Cal in-kind support rules. So, what's our takeaway here? Well, an irrevocable trust drafted to hold a person's $130,000 exemption is not going to be counted as an asset because it's exempt under the $130,000 rule, even if it is otherwise not exempt or unavailable. Just keep it under 130. Retained but undistributed income will not be counted as income to the individual. That the regulations do say that distributed income or asset are counted as income. So be aware of this. Now, although the regulations seem to say this, the application of this by DHCS is uncertain right now. They have indicated that they may not be applying that logic to this type of trust. We don't really know right now. I'd be hopeful that we don't even have to be concerned about this. I think for the attorneys out there and who are drafting these and assuming a certain amount of responsibility and liability for other people, it's nice to be cautious. It's nice to understand what could go wrong. I think it's our lot in life to be worrying about things that never happen because they could happen. And I think until we know how Medi-Cal is going to interpret this and whether or not they're going to apply the regulations, the way the regulations themselves seem to read, I think it is smart to keep, and I intend to advise my clients that for now, the distributions from the $130,000 trust will typically be confined to housing, utilities, and food, maybe clothing. You know, that's big though. There's a lot you can do in the context of housing and rent and the like. Now, this is a little counterintuitive. I know for those of you that deal with SSI, we are used to thinking, oh, gee, there's some ISM if we do any of these things. Let's just stick to these other things, you know, like Disneyland and vacations and the like. There's no ISM there. We don't have to worry about it. So this, again, you got to turn your head around about a 180 to see this, but there it is. Now, again, remember, when you distribute that ISM, distribute less than 100% of that item. So what happens if there is an ISM assessment that if you distribute 100% of a category? Well, remember that Medi-Cal is not a cash benefit. So they don't have any dollars they can dock you. So what they do is they take what they, any income that they are going to assess against you and add it to your prior income. So right now, if you are on a zero share of cost Medi-Cal, such as ABD Medi-Cal or the FPL 138 Medi-Cal, your your income limit is $1,564. So if you have income that puts you over, that's a problem. Now, if it's long-term care Medi-Cal, there is no income test for eligibility, but it is going to augment your share of cost dollar for dollar. So that's a waste as well. The problem with the community-based programs and going over that 1564 is the share of cost. You know, if you go $2 over, that doesn't mean you have a $2 share of cost, if it only. As soon as you go over, it triggers an assessment, an analysis of your share of cost of all income above the maintenance need level, which is currently $600. So that means that $1, that can cost over $900 in share costs, and that's a big bite. So that's what you got to be wary of. By the way, a tip here is if you have somebody that walks in and they've got $16.90 or something like that, a lot of people are walking around without dental or vision insurance. That's the number one way to get it back under, because that's an allowable deduction. So getting quality in dental insurance may be like pulling teeth. Sorry, couldn't help myself. But it doesn't much matter what quality of dental insurance is if it's costing you a couple $100 and it's saving you about $700-800. So a couple other tips here. Few random thoughts on these $130,000 trusts. Remember, if somebody's already on SSI or other means tested benefits, calculate the value of those. We've had some other speakers here that have gone in good detail about how what you should consider. Strongly recommend those presentations. It's an important analysis. So whether or not it's worthwhile to lose the other benefits for the $130,000 is a case-by-case analysis, and get help if you need it. Here's a thought though. Remember that if you take $130,000 and you put it in a 1% CD, it's going to earn about $108 a month. So if their SSI is less than that, and the SSI and other benefits, why wouldn't you do this? If it's more, maybe not. And people get emotionally vested in their benefits too. So don't put exempt or unavailable property in that. That's a waste of money. If you spend it down and you got other funds available, don't hesitate to top it off. Don't let it grow above that limit. Distribute it. If there's a structured settlement out there at the beginning, maybe it can be negotiated to top this off periodically. If it's a unified trust you've done with a special needs sub-trust, which either unified or freestanding is a good idea. There might be other money, or there might be other reasons to have these able to transfer from the 130 to the sub-trust, such as somebody that moves to another state. So let's look at a couple examples here. Susan's been in a skilled nursing facility for 3 years, and these are just general brainstorming of what can this 130 going from 2 to 130 do for us. She has a $350,000 recovery claim because she's been in a SNF for 3 years. She has no capacity. She's over 65 and she's inheriting $320,000. Well, the attorney that brought this to me recently was thinking D4C, she'd get to keep her benefits, but we knew as soon as she passed, it was all gone. So rather than the D4C, private pay until she dies, or the balance is 130, whichever comes first. If she survives, set up the Medi-Cal trust, this 130 trust, she will qualify because she'll be back under, and we'll save 130,000. So you get the exact same, you get to stay in the same SNF, get the same level of care for the same period of time, except the family is guaranteed 130,000 instead of nothing. So that'll make some people happy. Another example of a way you might use this, Alex is in a SNF. He was in an accident and has a TBI. He's only 59 and he's got an IRA worth $120,000. So while he's in the SNF, it's the IRA, as far as the IRS is concerned, does not have to have an RMD, but we know that Medi-Cal will count it as an available asset, if it's not in payout. So we put it in payout because that were the rules, and it's still the rules until July. Well, let's take it out as soon as it's July. Take it off of payout. It will now be a countable asset. Who cares? It's worth 120. It's under the limit. Last year, about $4,597 was distributed in countable income.
Thank you, Phil. For our next perspective, I'd like to introduce Tanis Kelly. Tanis is a settlement consultant who partners with leading law firms to develop customized settlement solutions for injured claimants. She's actually a former litigation attorney, and she knows what drives a successful settlement resolution. Her thorough knowledge of government benefits, structured settlements, and trusts, along with access to top industry experts in leading resolutions, Medicare set-asides, and mass torts administration, create a well-rounded and efficient method for resolving claims. Tanis is going to share with us her perspective of AB 133 as a settlement planner and some possible strategies to deal with cases where structuring the settlement may take advantage of these new options for cases brought before the expected elimination of the resource test in 2024. Hey, welcome, Tanis, and thank you for sharing your perspective from the viewpoint of a settlement planner.
Thank you, Steve. I'm Tanis Kelly, and I'm a settlement consultant with Sage Settlement Consulting. I wanted to share with you how those of us that are working with plaintiffs receiving a settlement, how we perceive the impact of AB 133 on our planning. So as a settlement consultant, I work with clients that have been through litigation and are receiving a sum of money, and they are evaluating whether that amount of money is enough to take care of their needs over the course of their lifetime. Often, as part of the planning process to evaluate whether it's enough money, we're looking at, whether government benefits are able to be preserved, what benefits those will provide, how we can preserve those benefits in order to maximize the quality of life for my clients. And with AB 133, we're going to see some changes, and my clients will have more options now that we see AB 133 coming into effect. What is AB 133? AB 133 is an assembly bill that, among other things, raises the asset limit for Medi-Cal programs from $2,000 to $130,000 for an individual. When will it go into effect? Starting on July 1st of 2022, that asset limit will increase. We expect stage 2 to eliminate the asset limit entirely in 2024. Why is this important for clients? Well, clients that are receiving a modest settlement may be able to avoid a spend down or a special needs trust entirely. They may be able to take their settlement and put it into a bank account without worrying about their Medi-Cal benefits being disrupted. Clients that are receiving a more sizable settlement may be able to utilize an irrevocable AB 133 trust or a Medi-Cal preservation trust that could provide them greater flexibility to ensure that they're able to accomplish their goals, gift money to friends within the resource limit, and ensure that their assets pass to their heirs after death. Structured settlements can still be utilized to ensure that a client's needs are met for the long-term future, but they will need to be placed into a irrevocable trust or a special needs trust in order to ensure they don't count against the income limit that is still in place for Medi-Cal programs. So as you can see, the income limit for Medi-Cal programs is not affected by Assembly Bill 133. Currently, the income limit is $1,482 a month. This would include interest income or structure income that's paid outside of an irrevocable trust or a special needs trust. This income limit will still be in place after July and in 2024 when we expect the asset limit to be lifted. So if you can see in this slide, I'm showing that the asset limit is really the only thing that's going to be impacted. And the reason why that's important is the way that we plan with clients who are receiving a sizable sum, or they're looking to structure and have the guarantee of periodic payments. We really need to be aware of how that income limit may impact their access to Medi-Cal. So prior to this upcoming July, how we've planned in the past is we've advised clients that in order to preserve access to Medi-Cal, they really have three options. One is to spend the funds down below the asset limit of $2,000 for an individual or $3,000 for a married couple, within the same calendar month that they receive it. The second option is to place those funds into a special needs trust. And the third would be to place up to $16,000 a year into an ABLE account for eligible individuals. Starting in July, clients will have more options. Clients can take up to $130,000 outside of a trust or in a less restrictive, irrevocable trust that would allow them to earn interest on those funds without counting against that income limit. They can still place funds in a special needs trust, and they can always structure their funds to feed into a less restrictive trust. The benefits of an irrevocable AB133 or Medi-Cal Preservation Trust are numerous. For starters, with a typical special needs trust, Medi-Cal has a right to reimbursement when the client passes away. In this case, clients that are using an irrevocable trust, they can pass any assets that are in that trust at their death to heirs. And so that's an important factor for clients to consider. Another aspect that's beneficial for these irrevocable trusts are that they are more flexible. Clients now can own more than one home. They can own more than one vehicle. They can run a business. They can, do some of their own investments that may have been more restricted when with a professional trustee in a special needs trust. And come 2024, when we anticipate the asset limit will be lifted entirely, this is really when, the whole landscape will change for clients, because now an irrevocable trust will be a very attractive alternative to a special needs trust. It will give clients maximum flexibility while still preserving access to Medi-Cal programs like in-home support and long-term care. The role for a special needs trust, in our post-2024 world is really going to be clients that are dependent upon SSI and benefits that are looking at, still have a lower asset limit, a lower asset threshold. So the asset threshold for SSI is still $2,000. So any client that needs to preserve that SSI, an irrevocable AB133 trust is not going to be the right solution. So as part of, the role of a settlement consultant is to walk through, what benefits will be impacted, which ones will be preserved and saved, and what are the different ways that you could accomplish saving those benefits. And so this is kind of a visual of how it could be set up, either starting now or in the post-2024 world, when funds that are inside an irrevocable AB133 trust will not disqualify a client from Medi-Cal benefits. And so here we could have funds that go into a trust. Initially, we could do a sub-special needs trust within that irrevocable trust, and funds that they need between now and 2024 could be placed in there, such that their benefits would not be impacted, even if it's over $130,000. They can utilize a structured settlement annuity or a market-based structured settlement where part of their settlement would be deferred and it would pay into the trust, the irrevocable AB133 trust, after 2024 when the asset limits have lifted. This would allow a client that's receiving funds today to defer them or some of them until a point in time when the asset limit's completely lifted, thereby maximizing their flexibility and ability to pass those assets to heirs. When I'm working with clients to look at the value of benefits and what is it exactly that we're preserving, and is it worth setting up an irrevocable trust or a special needs trust, I often price out what is the cost to replace those benefits. And so here's just an example. And SSI provides $1,040 a month. The cost of replacing that, it's going to be $1,040 a month for someone's lifetime. The benefit for Calfresh for this particular client was $250 a month. Medi-Cal health insurance, the cost to replace it would be about $400 a month. And the value of in-home services and in-home operations is roughly 200. This client was receiving 283 hours a month of IHSS and 160 hours of LVN care. The cost to replace that with private pay wages would be $4,245 a month. So if you look at the total benefits that this client, this was a 18-year-old that obviously was receiving substantial benefits, his benefits are about $16,000 a month. And so when we look at, what does it take to replace those, utilizing a structured settlement, it would take about $7.8 million with a 2% COLA to replace those. And so that's enough money that the client said, I absolutely need to preserve these. And so we walk through with this client. We want to preserve benefits. Now let's look at the two options. We have the irrevocable trust with a sub special needs trust, or we could do a special needs trust right away. And in this case, we ended up doing a special needs trust right away in order to preserve the in-home support and the access to SSI. But a client that might not need SSI may say, let's start with a more modest sum. And in 2 years, let's have funds pay into an irrevocable trust. And I'll give up benefits for 2 years. Or let's do a sub trust where those assets are paying into a sub special needs trust. And that way I can preserve benefits, but still have some flexibility within the resource limit. So what is the value of a structured settlement in light of AB 133? There are pros and cons to a structured settlement, whether or not we have AB 133. Some of the benefits, now that clients will need to put funds into a trust, an irrevocable trust, in order to continue earning interest off of those funds, is that there's no trustee fee. There are tax-free gains for any personal injury or wrongful death claimant that's receiving a settlement that decides to structure. And there's peace of mind. Structured settlement annuities provide a guarantee that clients can rely on. Market-based structured settlements don't provide the same guarantee, but they provide the market upside potential that's tax-free. So it's a nice benefit if someone doesn't need the certainty of a structured settlement annuity. The benefit of having this available now, the structured settlement, to pay into an AB 133 trust, is that it would not disqualify them from benefits if they defer it and then receive it in the trust down the road when the asset limit has been lifted. So here's a case example to kind of put this into practice and put it into a real person. Let's say we have Bob, hypothetical Bob, and he's getting a $1 million settlement, which is expected to fund in July of 2022. Bob is going to have a couple options. Let's say Bob is a single dad and he's providing for his child, but he also is paralyzed and he needs in-home support to help him, with household services and caretaking. He can't afford to lose the in-home support, but he also still needs to support his child. Now with AB 133, he's going to have the ability to do both. He can put up to $130,000 in an irrevocable AB 133 trust and put other funds in a sub special needs trust. And if he wants and needs access to the rest of the million, he would put all of the other funds in that sub SNT where he could, where he'd preserve all of his benefits and he'd have $130,000 that is outside of that SNT that he could use to support his child. He could also put a lower amount into a sub SNT, what he needs over the next 2 years, presumably, and can have a structured settlement that pays into that irrevocable trust after 2024. With the resource limit being increased to $130,000, he can gift or spend on others up to $130,000. That gives him the ability to support his child. After 2024, when that resource limit is eliminated, he can support his child more fully and with more freedom. And so the way that we can utilize structured settlements to help clients really meet their goals, their life needs, and support their family, it's going to be a really interesting process to be able to help clients through these different solutions. some of the benefits and drawbacks of a plan like this for Bob. Number one, Bob has more flexibility while he's alive. So he can support his kid. He can start a business. He has the ability to gift within that resource limit of $130,000. When he passes away, he also is able to make sure that his kid is taken care of, that those funds, within that resource limit do go to his heirs, those funds within that AB133 trust. And the benefit of having a special needs trust is that, we preserve his access to in-home support and long-term care before the asset limit is lifted. We also protect his ability, if he decides to move out of state, to convert everything and push it into that special needs trust, which is important as we see people moving out of California, although he might not anymore with AB 133. And then we also see that if he has the ability to get off benefits down the road, that AB 133 trust can be a lot more flexible, and it really can let him live the best life that he's dreamed of. And so some of the drawbacks, there's always a drawback, right, is that deferring funds to after 2024 would limit his present access to those funds. And having funds in an AB 133 trust does impact his ability to invest and earn income off of those, because there is still an income limit for Medi-Cal. And so, really just thinking of AB 133 and how it's going to impact clients is really exciting for us at Sage Settlement Consulting, because it's going to offer a lot of options and flexibility to our clients that have been through a lot of hardship, and they need something like this to give them a way to not make impossible decisions between supporting your child or getting the in-home care you need. And so we're going to have a lot more flexibility. Their quality of life is going to be greatly improved. And if you have a client that needs help evaluating, how to explore what are the options, how do I preserve benefits, what makes the most sense given my circumstances, don't hesitate to reach out to Sage Settlement Consulting or an trust specialist to help with that. Thanks.
Thank you so much, Tanis. For our last but certainly not least perspective, I'd like to introduce a colleague, Herb Thomas from Kairos Fiduciary, to share his perspective as a trustee. But before we do that, let's go to our final code here, which is 3113. So that's 3113. Now remember, in order to get the form to enter the code in, if you don't have it in front of you, you go to gspt.org/attorney resources. So Herb has a thriving practice in Northern California here, and his interest in administration of special needs trusts holds a personal significance since he has a child diagnosed with special needs. So Herb understands what parents and persons who are injured need to consider as they move forward with their lives. As we like to say, Herb is living the dream. Herb has years of experience in special needs trust and settlement trust administration in the state of California and nationwide, and has a depth of knowledge in conservatorships, public advocacy, and probate administration. He is a California licensed private fiduciary, and as an aside, his number is number 86, which means he was one of the first 100 fiduciaries to get licensed in the state of California. On top of that, he actually was a planner for Kaiser Foundation, so he actually understands Kaiser as well, which sometimes can be very valuable in itself. So Herb, I want to thank you so much for joining us today and sharing your perspectives as a fiduciary about AB 133 and how that might affect your practice and the persons with disabilities and seniors that you serve.
Thank you, Steve. Good day, everyone. Steve said, my name is Herb Thomas. I'm a private professional fiduciary, and I'm here today to speak with you about AB 133 and the fiduciary's perspective. I'm coming to you from my own practice, which is Kairos Fiduciary Services, We focus and specialize in special needs trust and settlement trust administration. I'm also representing my partner, who is Lisa Soloway of Soloway Fiduciary, also known as SoloFid. And so today we're going to talk, like I said, about AB 131. Well, breaking news. Guess what? In case you missed the good news, it's worth repeating. California budget in 2021 included the elimination of the Medi-Cal acid test. So as of July 1st, 2022, the state will raise the asset limit in the Medi-Cal program serving older people and people with disabilities to $130,000 for an individual, and then $65,000 for each additional family member, up to 10. This increase will allow many people to get on or stay on Medi-Cal without having to impoverish themselves. Here's what we're going to cover. We'll cover how AB 133 will affect existing special needs trusts. We'll talk about what's changed, what stays the same. We'll have some considerations for S&Ts in the pipeline. We'll talk about expanded options. And we will also talk about something called the Medi-Cal Preservation Trust. Well, how will AB 133 affect existing S&Ts? We've got to think about the effect on first-party S&Ts, third-party S&Ts, and also pooled special needs trusts. AB 133, what has changed for first-party S&Ts? With the advent of the new law, which will allow individuals who are not receiving SSI, which also includes Medi-Cal, they'll be able to save up to $130,000 as a resource starting July 1st, 2022. Another pending portion of the law may allow resource limit to become unlimited in 2024. So it'll be able to have more than $130,000 as a resource, but is unlimited. So let's talk about the definition of a resource. It's any kind of liquid or non-liquid asset. So for example, well, there's cash, there's cars, there's jewelry, stocks, bonds, boats, trailers, trucks, life insurance policies, etc. And for most fiduciaries, and maybe most people in general, we think of resources normally as cash. Well, further in the presentation, we'll give some examples of how a resource is unlimited by the use of cars and homes. So what stays the same? Starting in April of 2022, the income limit for an individual aged in the age and disabled program of Medi-Cal, and that's generally people from the age of 19 through 65, their income will rise from $17,084 per year, or $1,482 per month, to $18,768 per year, or $1,564 per month, meaning that they will be able to have that type of income and still be eligible for Medi-Cal with very low share of costs. Now, the income limit rules stay the same, as I had mentioned. However, Medi-Cal Recovery rules stay the same too. And by recovery, what I mean is, at the event of someone's passing or leaving a special needs trust, terminating the trust early, Medi-Cal seeks to recover expenses that were extended in that person's behalf. So you would get a Medi-Cal bill, they would still want a payment for services. And there are some ways around this with the AB 133, but for right now, the recovery limit stays the same. Now, AB 133 has potential impact on first-party S&Ts beneficiaries who are receiving supplemental security income. Currently, a single person on SSI is only allowed to have $2,000 as a resource, as a cash resource, or even as a personal property resource, such as a vehicle. They can have a vehicle that is worth, tens of thousands of dollars, but they can't have two. Okay. So for right now, as I stated, that an individual can have $2,000 a couple can have $3,000 in resources. Now, if the individual on SSI exceeds those values, they will lose their monthly income benefits and will need to seek Medi-Cal separately. The trust beneficiary and the trust drafting attorney could discuss the possibility of foregoing the SSI income and apply separately for Medi-Cal. So that is one impact. Now, AB 133 is a boon for first-party S&T beneficiaries who are not receiving SSI. People who are not receiving SSI but are receiving Social Security Disability Income, or SSDI, or Childhood Disability Income, they are able to save up to the $130,000 per single person for resources for Medi-Cal starting July 1st. And then, of course, once again, in 2024, the belief is that that resource limit will go away. Now, these saved funds can be used for a variety of purposes, for wardrobe, for pets, for education, for whatever expenses, repairs to a vehicle. Some people like to collect vehicles and work on them. It can be used for that. Once again, income rules and share of cost rules for Medi-Cal Recovery still apply. So let's just examine and look at the income rules for Medi-Cal, including share of costs and Medi-Cal Recovery. There are a few programs that include and exclude income from Medi-Cal beneficiaries. However, most adults are eligible for Medi-Cal if their monthly income is 138% or less of the federal poverty level. Now, let's just kind of jump ahead here and look at, because we've talked about some of these figures that are in that slide. So let's just talk about the share of costs. Currently, Medi-Cal imposes a share of costs for people in the aged and disabled federal poverty program. And normally that share of costs is anything in their income that's over $600. So the first $600 is excluded. That's given to the person without having to provide share of costs. But anything above $600 is their share of costs for Medi-Cal services for that particular month. Medi-Cal Recovery. The Medi-Cal program seeks repayment for certain Medi-Cal beneficiaries, including the estates of deceased people or people who want to terminate their trust early. Repayment only applies to people who own assets. So, of course, Medi-Cal can't collect on you if you don't have any assets. So, in other words, if you die, you leave nothing, there's nothing to recover. However, if you die and you leave it where it's not protected, where Medi-Cal can recover, they will seek recovery, and that will continue. Similar for special needs trust right now. If you terminate the trust early, Medi-Cal will seek repayment for services that were provided. Let's talk about some of the key concepts here. So when we look at the resource increase, it provides a lot of latitude. So certainly for years, fiduciaries could only buy a beneficiary a single vehicle. This is what I talked about earlier. But now the second vehicle would not be counted. It would be an excluded resource. So think about this. We almost certainly focus on funds, but if you stop and think about it, that vehicle, it has an intrinsic value. And so the value is what Medi-Cal is looking at, not necessarily the second car. Because you could actually buy it right now with the law the way it exists. You could buy a person a second car. It would just cut into their resource limit. So this goes away. So from now on, starting July 1st, you can buy that second car if they need it. And we'll talk about how that plays out. And not only does it include vehicles, but it includes things like boats and trailers. So here's the concept. Bob needs a backup vehicle. Bob has a wheelchair van and lives in a rural community. He wants to purchase a second vehicle, which was, of course, supported by his care manager. So you got the recommendation that, yes, he needs this vehicle. And the reason is he wants to have it in case one fails and he doesn't want to be stranded. As I stated earlier, prior to AB 133, the second van would eat into his $2,000 resource limit. but going forward, he won't have to worry about that. Another key concept. Prior to the change in law, an early termination is the kiss of death for a D4A, that's a self-settled special needs trust, or a pooled special needs trust, which is also known as a D4C. However, with AB 133, and it's something we are calling the Medi-Cal Preservation Trust, it does not require a payback on death or early termination. So this adds some more options for beneficiaries not to be trapped in the, special needs trust or pooled special needs trust if it's not in their best interest. I'll have a few more points on the Medi-Cal Preservation Trust, but other presenters will speak about it more in depth. Key concept. Bob buys a house. Bob wants a house. And with a D4A or a pooled special needs trust, holding the interest in the house was subjected to payback. Now, what we're calling an AB 133 trust or a Medi-Cal Preservation Trust, we don't have that hazard. See, the trustee can buy Bob the house, but when he dies, Bob can leave it to whomever he wants. Now, this is more equitable for holding houses for parents of severely disabled children. You've seen these scenarios when the house is purchased and then the child dies. And then because of the current law, the way it exists, parents the home will be subject to a Medi-Cal payback. Well, in this instance, parents, of course, have dedicated their lives. They've lived there. They've foregone purchasing a home on their own. And so now they're going to lose their home. Some other benefits include tax relief because you get to step up in basis, but that's for a tax attorney to discuss with you. How will AB 133 affect third-party special needs trusts? Well, I'm here to tell you it has little to no impact on third-party S&Ts for people who are not on SSI. So people who are on childhood disability benefits or Social Security disability income, 133, it just continues, life just continues. They get to have resources and beyond Medi-Cal that are above the current limits of $2,000 up to $130,000 and then unlimited, hopefully in 2024. Now let's just talk a little bit about how third-party S&Ts, where they were created and what they do and what effect this will have. So third-party S&Ts are typically created because an individual has a disability and is believed to be unable to manage the inheritance. So the resources in a third-party special needs trust don't belong to that person. They belong to another person. It is unlikely that you would, as a trustee, release up to $130,000 in cash to a third-party special needs beneficiary, particularly since there may be some remainder beneficiaries and you would run into some legal problems. So you probably won't be giving them the trust assets, but perhaps they can earn funds or receive funds from another source. And once again, they could have those funds, use them as they want, and they will be unlimited perhaps in 2024. And then as of July of this year, up to $130,000 they can maintain. So far we've talked about the effects of AB 133 on first-party special needs trusts. We've talked about the effects of AB 133 on third-party special needs trusts. Let's switch our attention to the effects of AB 133 on pooled special needs trusts. Well, I have some interesting and good news for you. There's nothing different. It pretty much stays the same. There's a caveat here. There are 4 reasons we do need to consider AB 133 when it comes to pooled special needs trusts. But the income rules, for the most part, are the same. The recovery rules are the same. If you're on SSI, any resource over $2,000 will be held against you. It'll be considered a resource. It'll affect your Medi-Cal eligibility. However, just want to talk about this. So it used to be that the pooled special needs trust or the D4C trust was the only game in town for people over age 65 who were seeking some type of special needs trust. So they wanted to self-settle. They were over age 65. They could not set up in a first-party special needs trust, had to go to a pooled special needs trust. Now, the thing about the Medi-Cal Preservation Trust, you can set this trust up as an option or an alternative to a pooled special needs trust. With it, there is no age limitation. So over age 65, you can still set this up. There is no disability limitation. So you're over age 65, disability is not included in your ability to set this Medi-Cal Preservation Trust up. So you get all the benefits of that. So this gives you, the fiduciary, more options, the planning attorney, more options, the client, more options as well. Now, one last point here. This is only if you're receiving Medi-Cal. This is not an option if you are on SSI. So once again, if you're an SSI beneficiary, that's your entire income, this won't work for you. So let's talk about some considerations for SMTs in the pipeline. The concept of AB133 is new, and planning attorneys were not able to draft trusts for the cases that are in the court pipeline. So for instance, if you have a case being heard in June of 2022, it's not going to fit into the AB133 scenario. If you've drafted and it's going to be heard in July or August, but it's already submitted to the court, as you know, we have these long court dates, particularly in Northern California, this won't work. So you'll need to review. Let's talk about this a little bit more in depth. You know, AB133 is not retroactive. So even though you get your case, your trust approved by the court, it's drafted to fit prior to July 22, first party special needs trust in particular, you may have to revise that trust or reform that trust. I'm not sure of the exact legal term that takes place. You know, for court cases that have been filed and are likely to be heard and granted, as I said, a quick review should take place. And it would be prudent to have a review done by an attorney to see if it can be reformed. Now, let's talk about some expanded options for AB133. What are some options for people who need the protection of a trust? So unlike a self-settled special needs trust, the Medi-Cal Preservation Trust can be terminated if at some point in the future it's best for the beneficiary. There are a number of reasons. Recovery is one issue that could be considered. So you've had someone who has been injured, has a special needs trust, and they're able to function. Someone with high functioning autism, and I know it's a term that's going out of style, but someone who has autism and has been functioning at a higher level may be able to handle these resources. Maybe that trust can be terminated, particularly if it's a first-party special needs trust. Now, if it's a D4A, a first-party special needs trust, and is determined to be in the best interest of the beneficiary, for instance, if they move out of state or become SSI eligible, then the Medi-Cal Preservation Trust can convert to a D4A trust. So let's talk about the features and benefits of managing a Medi-Cal Preservation Trust. And I'm not going to go into great detail. I'm going to leave that up to the attorneys to do, but I'm going to talk about a few things. So for trust beneficiaries, where it's practical to forego the SSI payment and apply for Medi-Cal separately, it would be a blessing not to have to deal with the Social Security Administration with their ongoing audits. I don't know if you've ever been subjected to one of these. I happen to have a large caseload. They come into my office. They spend 2 days in my office going through every SSI beneficiary who has a special needs trust, because I have a bunch of them. Or periodically, I'm called down to the Social Security office. That was before COVID. And, I would spend several hours, even though I had an appointment, would spend several hours waiting to meet with an eligibility worker to provide the documentation that they need. Some more features. I just want to talk about managing Medi-Cal Preservation Trust. The fiduciary is not necessarily scot-free when it comes to these trusts because there are some reporting requirements that may come up that we don't know about yet. So as we talked about, recovery is still pretty much on the table. So at the event of someone's passing or termination of a special needs trust, the Department of Healthcare Services may want to review what assets the person has. If they're outside the trust, maybe you know about them, maybe you don't. It would be important to work with your beneficiary to get that information. It would be important for you to continue to maintain good documentation to supply to the Department of Healthcare Services. And as you may be aware of, normally when the recovery comes from them, you can advocate to lower that recovery bill. I've seen it where there's hundreds of thousands of dollars and it's been reduced to tens of thousands of dollars. Well, thank you so much for your attention. I hope you've learned something today. There will be more information on the Medi-Cal Preservation Trust. And from my partner, Lisa Soloway, Soloway Fiduciaries, also known as SoloFid, and myself, Herb Thomas of Kairos Fiduciary, I thank you for your attention.
Thank you, Herb. As we can see, this really expands options in certain situations for administering not only future trust, but existing trust for Medi-Cal recipients. So where do we go from here? First off, to the members of our work group, I want to thank you so much for the hard work that you put into this. We spent months studying this, and I hope what you got out of these presentations is that even though this is a simple change, in some situations, this can have a profound benefit for persons with disabilities and seniors that we serve. We will also continue to work on upcoming developments and strategies to harness these changes when appropriate for the betterment of our community. And we anticipate a follow-up webinar to be announced soon, which will include case studies, suggested language to include in what we're calling a Medi-Cal Preservation Trust, as well as sample petitions for cases under court supervision. For those of you that are planning cases now here that won't actually be implemented until after July of 2022, in many ways, once again, AB133 is in effect now, especially if you have cases that are being that won't be heard until after July. So I invite all professionals that do planning for persons with disabilities to continue to follow developments. And the best way to do that and to get into our mailing list is to email amy@gspt.org. That is AMY@gspt.org. Also, it is important to get the word out. So please share this webinar far and wide here. And on top of that, many of us are available to do presentations and educational events in your community. So to arrange a presentation, once again, email amy@gspt.org. So once again, I want to thank you for attending today. Always interested in your feedback. And so with that, we're going to close out this webinar. And I want to thank you so much for watching, and happy advocating.